Good afternoon, everyone. Thank you for joining us today for our part two in this series, Navigating PBM Audits, Ensuring Pharmacy Compliance, and Mitigating Risk. My name is Dae Lee. I'm a pharmacist attorney and a partner at Frier Levitt Life Sciences Group. In today's webinar, I am thrilled to be joined by my colleagues, Harini Bapati and Adam Farkas. As attorneys at Frier Levitt, a law firm with a focus on healthcare and life sciences industries, we focus our practices on counseling pharmacies on a wide range of PBM-related matters, including network exits, defending and fighting audits, network termination, and wrongful recruitment actions and investigations. Leveraging our knowledge and extensive experience, we offer guidance of strategies and best practices to protect your pharmacy from adverse actions imposed by, different payers, including PBMs. In today's webinar, we'll discuss the trends that we've seen in 2023 and give you some insights as to what you can do to prepare yourself and your pharmacy for the challenges in 2024. The webinar is strictly for educational purposes only. So we're not giving legal advice or legal opinion. And as I indicated before, our firm is a national boutique law firm focused exclusively on healthcare and life sciences. We represent different stakeholders in those industries. Harini, Adam, and I, we mainly represent independent pharmacies, plan sponsors, manufacturers, and wholesalers. For the pharmacies, we handle a lot of PBM related issues and board of pharmacy and government investigations. As I'm sure you all know, pharmacies are facing increasing risk when it comes to PBM audits. Properly addressing audit issues and implement preventive measures are crucial to ensuring a positive audit result. Throughout 2023, we've seen an increase in PBM audits and investigations over pharmacies and their network participation. I mean, these actions have resulted in significant monetary penalties, through recoupment, also disruptions in network operations. And of course, it triggered further investigations by other licensing authorities, including State Board of Pharmacy and other government agencies. So as we transition into 2024, we would like to advise pharmacies what has happened in the past in 2023 and what should pharmacists do and prepare for the upcoming new year. I'll hand it over to Harini.
Yep, like Dae mentioned, we work alongside one another. My name is Harini Bapati. I'm an associate in the life sciences group here. I primarily represent pharmacies, whether that be retail, mail order, specialty, home infusion, et cetera, along with dispensing physician providers on a wide range of PBM related issues, just as Dae mentioned. Like he said, we're seeing a lot of changes from 2023 going into 2024. So we really look forward to speaking on those types of issues today.
My name's Adam Farkas. I'm also an associate in Frier Levitt's Life Science Group. Like Dae and Harini have mentioned, a lot of what I do is working with pharmacies in matters dealing with PBMs, third-party payers, State Board of Pharmacy actions, and I also work alongside Dae quite often, representing plan sponsors in matters against PBMs as well. And yeah, just like Dae and Harini have said, there's a lot of change going on in the industry from 2023 to 2024. So looking forward to today's webinar and getting to talk to you guys.
Alrighty, then let's move into our learning objectives. Harini?
Yep. So if anyone had joined us for a previous webinar, we went over an audit checklist, which essentially outlined proactive measures that pharmacies could engage in to be able to prevent any sort of negative and adverse audit findings and in turn terminations. And the reason that we had developed and updated that list or that checklist was really because we were observing additional types of discrepancies that were popping up during the course of an audit or during the course of pharmacies' participation in PBMs networks. And so for that reason, we're observing what we've observed in the course of 2023, just so that pharmacies could be aware of what's happening in the landscape and also what to keep an eye out for their own practices. And to that extent, we'll also go into a couple of different case studies. Obviously, like I said, we represent a host and a wide range of pharmacy providers. So the issues that they face range, the types of discrepancies they face range, as well as even the discrepancy amounts. And so when we go into these studies, we'll discuss briefly about the audit and dispute resolution processes that pharmacies might have available to them with respect to their PBMs. And then we'll also identify perspectives for 2024 and what pharmacies could expect going into next year, especially as we see sort of the year-end review and the year-end cleanup that we know that a lot of PBMs look for when they are trying to close out the calendar year. So with that, we'll jump straight into sort of the trends that we've seen in the past calendar year and ongoing. One of the first issues that we've observed are hub pharmacy arrangements. We've seen an increase in the scrutiny of pharmacies that have entered into hub arrangements, and obviously it's one of the ways for PBMs to become aware of hub arrangements absent a disclosure of the pharmacy of having entered into one is really the types of medications and the drugs for which they're dispensing, which have been known to have been received through hub arrangements. So we've seen PBMs have different terms and conditions as to the extent that a pharmacy can participate in a hub. For example, you can participate, but you need to ask for permission. So there's certain terms and conditions that pharmacies should be aware of before they enter into hub pharmacy arrangements. One of the important things to keep in mind is that while a hub pharmacy arrangement might be completely okay from a regulatory perspective, it might not be from a PBM perspective. And so it's important to keep that in mind. For example, we've seen a particular PBM take concern with the outsourcing of the collection of copays by the hub versus the pharmacy, even though the collection of copay was happening, 100% of the copay was being collected by the pharmacy. By the hub, we've seen PBMs take concern that the pharmacy was outsourcing that collection. Again, perhaps fine from a regulatory perspective, but not from the contractual perspective of the PBM's provider agreement. Similarly, we see issues with hub pharmacy arrangements with respect to test claims, as well as the restricted use of NPI in the pharmacy's credentials. Essentially, the concern that the pharmacy is giving out the information, their own provider credentials, to allow for a third party to be able to process claims under their credentials without disclosure, without authorization. Another one of the things that we're seeing a lot of, and that's not included in this slide, but it's related, just considering manufacturers, is a lot of manufacturer-driven actions against pharmacies. For example, we've seen a lot of instances, especially in the diabetic testing supply space, as well as recently for any manufacturers that have coupons, where they'll allege that the pharmacy wasn't either sourcing the products properly, either from non-authorized distributors, or where the pharmacy wasn't purchasing sufficient claims to otherwise support the number of coupons or claims that they were using. And so for those reasons, we've seen a lot more manufacturers go after pharmacies individually to collect on sort of a lost rebate for themselves from the PBMs. And so while the pharmacies might not have a contractual relationship with the manufacturer, there are certainly those are certain considerations to take in when you're either how you're sourcing your product or the fact that you should ensure that you're sourcing sufficient product to support the use of any claims that are being submitted. Moving on to prior authorizations, this has been a topic of concern, I'd say, for a few years now, more recent years, and definitely in 2023. We've seen a lot of PBMs take concern with prior authorizations, but we've also seen a lot of plans, individual plans also take issue with prior authorizations. To that extent, we've seen plans actually have recordings of pharmacies that have called in acting on behalf of a prescriber to just check in on the status. Again, the language in which the pharmacy uses is really crucial as to the prior authorization process. And to that end, PBMs have different limitations on how involved or not involved a pharmacy can be in the prior authorization process. So that is certainly something to keep in mind. And all pharmacies, I'd say, should be encouraged to keep a prior authorization policy in place to the extent that they have any involvement in the prior auth process. Again, when it comes down to prior auths, it should be submitted with correct, valid information, again, to the extent that the pharmacy is permitted to go ahead and submit a PA on the prescriber's behalf, and also in a manner that doesn't disguise who's actually the one submitting the prior auth as well. And so with that, we've seen a lot of scrutiny from PBMs as to the improper submission of PAs by pharmacies, or with inaccurate information not having been submitted to be able to get a prior authorization. So
Bernie, I'm
Yeah.
sorry to interrupt you, but isn't the PA more of a PBM driven requirement rather than like, black letter law prohibition?
Sure. So again, there's certain arrangements that a pharmacy could enter into to assist in prior authorizations, which we would certainly analyze to see if that's essentially okay under the law or from a regulatory perspective. But what pharmacies fail to consider is that they are under a contract with their respective PBM who might otherwise place limitations on their ability to process PBMs. So for example, a particular PBM might say, pharmacy, you're not allowed to engage in the PA process at all. Another PBM might say, pharmacy, there's 6 different types of PAs, and pharmacy, you're allowed to do 2 out of 6 of these PAs. For example, like an emergency PA might be one of them. And so it's really important that while it might be, again, okay from a regulatory perspective, that we're also looking at it from the PBM perspective, because the PBM is looking, and when they audit, they're looking at the way the pharmacy is participating in relation to their own terms and conditions. They're not necessarily saying, hey, pharmacy, you're breaking the law, but they're saying, pharmacy, you're not acting in compliance with our terms and conditions. And so I do think that's going to continue to be a point of scrutiny for a lot of PBMs going into 2024 as well. And I think that's going to continue as we've seen a lot more review and actions in the past calendar year. I'd say more so than we've seen in the past few years.
Okay, thank you. All right, let's move on to the next slide. Another PBM audit trends is deliveries and proof of receipt. As you guys know, PBMs waived delivery and mailing limitations during the height of COVID and when the public health emergency was enacted. But now that has been lifted and it actually expired. So now PBMs are going back to their older requirement or the previous requirement to define retail pharmacy as, pharmacies that dispense medications in person at the point of sale and not mailing or shipping the products to the patients, which is bizarre in this day and age that you would require a retail pharmacy to just stick with brick and mortar location and just dispense the medications in person and defines it as at the point of sale. But in any event, PBMs, major PBMs have rolled back their mailing or shipping waiver, and now pharmacies are getting audited on these claims. And not only audits, major PBMs such as Optum, Optum will send a cease and desist notice to the pharmacy, prompting the pharmacy to stop mailing. Otherwise, the pharmacy may likely be terminated from Optum's network. And obviously these claims will be subject to recoupment by Optum. And speaking of another major PBM, Express Scripts, ESI will not send you a cease and desist. At least to my knowledge, they have not on hundreds of matters that I've handled. Rather, they send a request for a credential as a mail order pharmacy. And mail order pharmacy credentialing is onerous. It has a lot of requirements and is quite difficult for a retail pharmacy to get all the credentials within time that they give and try to get their credentialing approved. And in the event the pharmacy fails to do so, get the application approved by the allotted time, ESI will likely terminate the contract. And for Caremark, the other major PBM, they will identify these claims during routine audit, whether it be routine audit or their investigative audits, and try to ding the pharmacy on these claims for mailing or shipping these drugs, their drugs, to the patient. Another trend that I've and let me take a step back. So the they get, so these claims, obviously PBMs, they have the members' information, right? So they know, they could figure out the zip code of the member, and they could figure out the location of the pharmacy, and they try to use that knowledge in order to make a case that the pharmacy mailed. And also, when they issue notice of audit, they request a proof of delivery or signature logs. And a lot of times, when these medications are shipped or delivered to the patient, it is through the common carrier service. So the pharmacy, without knowing, just provide the proof of delivery, and PBMs will issue findings that the pharmacy is in violation of the provider manual. Moving on to the next trend is obviously the COVID-19 home test kits. A lot of pharmacies dispensed COVID-19 test kits when the public health emergency was issued. And now PBMs are focusing on these claims, and they try to allege that there has been drug invoice shortage, or a patient denied requesting it, or a patient didn't receive it, or they just say it's an invalid prescription and there are other various reasons that they could use in order to make allegation on these claims. And obviously, whenever a pharmacy faces an audit or fraud, waste, and abuse investigation, it puts a lot of pressure on the pharmacy and their staff. They have to take away the staff from servicing the patient, and instead they have to go through all these records, gather all the documents, and then have to respond to the audit and potential audit findings. Otherwise, the pharmacy will be subject to not only monetary recruitment, but also move into the case study number 1 relating to on the COVID-19 test kits. So we had a pharmacy client who underwent an audit from a major PBM, and the PBM placed about $100,000 of discrepancy on that pharmacy through that audit. And majority, if not all, of the discrepancies were on the COVID test kits. And the PBM alleged that the pharmacy were short on the purchases compared to the claims that the pharmacy billed to that PBM. This was a very unique issue, and we think that this will, continue to be an issue going into 2024, because the pharmacy actually had all the purchases. The PBM didn't recognize the purchases or didn't account for those purchases because in the PBM's mind, the distributor or the supplier of the test kits was not authorized to distribute the COVID-19 test kits. So they just said, the PBM just said, we're not going to give credit to any of these COVID test kits that were purchased by the pharmacy, dispensed to the patient, and then we're going to recoup 100,000. And plus, there was I want to say there was a 20% audit fee that they tried to charge to the pharmacy on top of that 100,000 discrepant amount, which is bizarre. So what happened? We got engaged. We went through the dispute resolution procedure warranted under that PBM's provider manual. So the life cycle of an audit, as you guys know, but if you don't know, you must know the life cycle, and because you have the right to appeal the finding. So the life cycle of an audit starts with a notice of audit, right? The pharmacy receives a notice of audit. The pharmacy responds back with the requested documentation, and the PBM issues the initial audit findings. In this case, it was 100,000 on all COVID-19 test kits. Then we collected all the supporting documents. We responded back with a robust appeal response. The PBM then issued the final findings. Sometimes, pharmacy think that they don't have any right to appeal the final findings. That's not so. Pharmacy has absolutely 100% right to appeal the final findings and submit a notice of dispute. Okay, and we submitted notice of dispute that prompted a dispute conference to be held between the attorneys from us and attorneys from that PBM. So we've exchanged, our arguments, and PBM ended up reversing all of the discrepancies. But in order to do so, like I said, the pharmacy had to dedicate its staff, time, and money to fight the allegations brought by the PBM. So in this instance, what we had to provide was the evidence of payment for those test kits that the pharmacy purchased. We also obtained a signed letter from the wholesaler indicating that at the time of the invoices, the wholesaler was shipping from a temporary location because there was another issue that PBM had. And we also provided the proof of the state agency's website that the wholesaler license was in good standing and was located at the appropriate address. So we jumped through multiple hoops in order to get the money back from that PBM. Keep in mind, like PBM can withhold money at any point, whether it be notice of audit point, initial audit findings, final findings, on top of that 20% that they try to charge. So when the audit was initiated, the pharmacy was already down the hole, like minus 100K when we first got engaged.
Just really quickly, Day,
Mhm.
when you were talking about the lifeline or like the timeline rather of an audit, and you raised that pharmacies should certainly dispute any sort of final findings. Another thing to keep in mind is that when you receive final findings, some PBMs, for example, Optum, will allow you to go ahead and further appeal through their administrative process any sort of audit findings. Similarly, an important thing to keep in mind is that many states have pharmacy fair audit laws, which you should certainly look into and leverage. Certain states have laws that prevent audit fees, for example. Certain states also have a requirement that you, as a pharmacy, especially in the case of an audit, be provided the opportunity to further dispute or appeal final findings within a given period of time. So those are some in-betweens of, say, just the appeal and the dispute process that some pharmacies would additionally be afforded some state protections, state audit law protections as well to keep in mind.
Exactly.
Okay, so moving on to some of the other audit trends that we've been seeing, mail order credentialing is something that Day got into a little bit. As he had mentioned, with the expiration of the public health emergency, PBMs are kind of pulling back on the less stringent guidelines that they had of pharmacies mailing and delivering prescriptions to patients throughout the pandemic. And as Day mentioned, this has kind of led to an increase in PBM action, whether it be the cease and desist notice that Day mentioned can ultimately lead to termination if the pharmacy doesn't adhere, requests to recredential as a mail order pharmacy, which can be time consuming and require a lot of commitment from the pharmacy to be able to fulfill, or whether it just be recruitment through audit findings that ding pharmacies for having mailed prescriptions, even if it was permitted during the public health emergency. Certain PBMs may have pulled back on their allowance of that practice, leading to potential repercussions for the pharmacy. Drug invoice shortages and some other common audit discrepancies that we see. PBMs regularly conduct invoice reconciliations where they'll pick a specific time period, they'll review the total purchases that a pharmacy has for a given drug and compare it to the total amount dispensed for that same drug over that same time period. This is bread and butter of PBMs, if you will. We see drug invoice shortage discrepancies in most audits that we see. And I think there's a couple different reasons for that. Drug invoice shortages are easier to manufacture, if you will, than some other discrepancy types because of that limited review period. Pharmacies' existing inventory may not be considered, so it might preserve or present some kind of illusion like there's drug invoice shortages, even though they might not actually exist. Other common audit findings that we see all the time include copay collection, member denials, whether it be denying receiving medication, denying requesting medication, or prescriber denials. And it's important to note that each of these discrepancy types require the pharmacy to then submit extensive documentation that the pharmacy may not even have readily available or be required to maintain under applicable state Board of Pharmacy regulations or laws. For example, I know one of the major PBMs likes to see bank statements or credit card merchant reports in support of copay collection. But there are limitations on what the pharmacy is able to obtain. Banks or credit card vendors might place a limitation on how far back you can obtain documents. So a credit card vendor may only allow a pharmacy to obtain 6 months of data. Well, that doesn't do the pharmacy much good if the audit time frame goes back 2 years. But again, like has been mentioned, there are some state fair audit laws that can be used to try to limit the amount of time that PBMs can review claims during an audit. And as far as chargebacks and payment withholdings from PBMs, this is pretty standard for pharmacy audits, whether it's coming from the PBM directly or it's a PSAO that's holding money. But the big issue, I think, with this is that PBMs may issue a notice of payment suspension. They may not provide any notice before they start withholding payment. And the payment withholding can come shortly after initial audit findings are issued, right before initial audit findings are issued. And the pharmacy may not even be aware of it until their next remittance report is issued and they see their paid claims. Oh, and I'm sorry, one other thing that I wanted to mention about chargebacks and payment withholdings. PBMs often withhold funds in excess of the amount at issue in an audit finding. So just for example, if there's $50,000 placed at issue, a PBM may withhold up to $60,000, $70,000, $80,000 before the pharmacy is able to receive payment again. And not only that, but as they mentioned, there are the audit fee that PBMs may tack on to audit findings that can be upwards of 20% of the total amount at issue. So you can see how if an audit finding gets into the tens of thousands of dollars or over $100,000, that 20% is significant, and it really hurts the pharmacy moving forward.
Right, and Adam, we've had numerous instances where PBMs continue to withhold, and then pharmacy had to demand that they release the funds held in excess of the audit, the discrepant amount on top of that audit fee.
Yep.
All right.
And I think as Farini mentioned earlier, there's also state laws that prevent the audit fee recovery. I think California is one of them. So it's another tool that pharmacies can use to try to leverage this practice. And moving on to the next case study, this kind of dives into drug inventory shortages more and also highlights how copay discrepancies are regularly seen in PBM audits. So we were retained in a matter where a pharmacy client received a significant audit findings from a PBM. It was just over $1.2 million. Placed in issue, nearly the entirety was due to drug invoice shortages, with some copay collection discrepancies still in there. So one thing that I think we need to stress that's really important for pharmacies to know, this is a significant audit, $1.2 million, but regardless of the amount at issue, it's so important that pharmacies contest all audit findings, use that contractual appeal process that's in your PBM provider manuals, because small audit amounts, they may not seem worth contesting at the time, but they often lead to additional PBM action down the road. For example, that can include termination, but recently we even handled a matter where a $28 audit finding led a PBM to force a pharmacy to impose a formal corrective action plan. And a corrective action plan, it may not seem that significant at the time, but again, it's just another thing that pharmacies need to consider, because the slightest deviation from that corrective action plan can then lead to another reason for the PBM to terminate down the road. So what do we do when we get an audit finding? What's the first thing that you should do? I think it's really important that pharmacies, digest and understand what the basis of the discrepancies identified in the audit findings are, because only by understanding that basis and the causes of those discrepancies, whether they're warranted or not, the cause of why the PBM is seeing discrepancies, understanding that basis is going to give you the best chance to address those discrepancies and overturn them.
It's funny that this, like, I want to know, I don't know if we'll ever find out whether PBMs apply the same standard to their own pharmacies.
Yeah, I doubt it.
I can say in most instances they don't. I've seen an instance where a PBM audited a pharmacy for using coupons on particular drug products that were otherwise not considered to be FDA approved. Pharmacy owner decided to test it out, took it to a chain pharmacy, and it worked. So I mean, we won't talk about which PBM and which chain pharmacy, but it worked. So I can't say that they apply the same standards, I'm sure. So things to keep in mind.
So as I was just saying, identifying the cause of the discrepancies is really important for a pharmacy to know how to address those discrepancies during the appeal process. So in this matter, the majority of the discrepancies were drug invoice shortages. And as I had mentioned, there are a lot of different causes for drug invoice shortages, one of them being a limited review period. So in this matter, if the review period was March 2021 through March 2022, the PBM would only look at purchases from February 2021 through March 2022. But that doesn't consider what the pharmacy may have bought in January or in December of 2020. So in this case, the pharmacy had a large supply of existing inventory. So how we addressed that issue, we expanded the look back period by providing additional dispensing data. So like I said, if the regular review period began in March 2021, we provided dispensing data from January and February 2021 to show that the pharmacy's purchases from January and February 2021 far exceeded what they dispensed in January and February. So the pharmacy's inventory before the audit period began was substantial, and it justified the claims billed to the PBM.
Yeah, we had to make additional arguments, legal and factual arguments for the PBM to accept it, accept those purchases.
Yeah. I think it gets into it a little bit on the next slide, but our initial appeal, the PBM was definitely hesitant to accept those earlier purchases and review that dispensing data. But as we move through the initial appeal into issuing a notice of dispute and going through the dispute resolution process in the PBM provider manual, which included being able to get on telephone calls with PBM counsel to kind of address these discrepancies, break down all of the purchases that the pharmacy had made, break down all of the claims that the pharmacy had submitted, where it became really irrefutable that no inventory shortages existed. And this back and forth with the PBM's counsel went on for months. We exchanged a lot of emails, a lot of telephone calls, but eventually we were successful and able to get a great result for our client here, reduce the audit findings by 99%, which was over $1.1 million.
And so while we covered a range of dollar amounts, obviously we talked about the 100K, we talked about the 1.1 million or the 1.2 million rather for the drug inventory shortages. It's certainly important for pharmacies to challenge audit results regardless of the recovery amount. A lot of the times we understand that pharmacies might see a smaller recovery amount and might not want to exhaust the resources to be able to even provide a written response back to the audit. But for example, like Adam mentioned, for a $68 audit fee, a PBM placed them under a corrective action plan, and even the smallest amount could lead to a corrective action plan. Further actions such as termination, which we've seen over smaller audit findings such as $2,000 for particular PBMs. Sometimes it's not the nature of the sometimes it's not the dollar amount of the findings, but more so the nature of the findings that leads a PBM to go ahead and terminate. In addition, PBM audits could escalate. We mentioned earlier that PBMs are known to report those findings, even though they're internal PBM audit-related findings, over to state boards of pharmacies or any other agencies. And so for those reasons, that could in turn cause discipline for the pharmacy, which importantly, discipline, if the pharmacy or any of its employees are disciplined, have to be reported to other PBMs as well. So it kind of is like it's a circle, I'd say. That's certainly something to keep in mind. And we'll just kind of go through another case study really quickly, just to highlight what happens in the instance of unresolved audit findings. In this particular instance, the pharmacy had received final audit findings, didn't want to further challenge it, again, given the smaller dollar amount, and didn't think to further take any action. But in turn, the PBM did and sought termination of the pharmacy, it was a nominal, it was a very relatively smaller dollar amount of not more than $30,000 to $20,000, but they were related to member denials in which patients had denied either requesting or receiving their medication. Again, the question is why and how could a patient deny receiving or requesting a medication when the pharmacy has been in constant contact with them and ensuring that the patient's receiving it through the appropriate delivery and tracking information. But yes, of course, a PBM says that they've contacted this patient or patients a whole year and a half later, and the patient couldn't recollect. And sometimes PBMs may be more inclined to take that as an express denial of the pharmacy service to them. And so in that instance, we had gone through the appeal process of the termination. We requested an appeal hearing, and then we went through the process of demonstrating why the underlying final audit results related to the member denials were without merit. And of course, in doing so, we provided significant documentation, contextual information, information such as attestations from the patients to demonstrate that they did in fact receive or request their medications. And so eventually the pharmacy was granted an appeal hearing to be able to address their basis of termination. However, in the process of that appeal hearing, the pharmacy was questioned not just about the issues related to the final audit results, which led to the termination, but also just about all of its overall business practices. And so one of the things to keep in mind is that audit findings could lead to termination, which could lead to a discussion not just about the audit results, but more so about the pharmacy's business practices. In this particular instance, the pharmacy was questioned about its marketing practices and asked to provide additional information, including the name of any sort of third party that it used, its business model, its overall practices, its delivery practices, sort of almost everything related to the pharmacy's operations. And thankfully, the pharmacy was responsive in a favorable manner to the PBM, and the PBM's termination, the pharmacy's termination for this particular pharmacy was overturned, with the exception that the pharmacy submitted a corrective action plan related to the member denials.
Alrighty, so what's in it for 2024, right? So 2024 will be an interesting year for pharmacies and PBMs, and as you may know, PBMs are facing legislative pressure on both federal and state level. There have been legislative updates that have already occurred and impacted PBMs. So while we anticipate that PBMs will be more aggressive in terms of conducting audits and maintaining integrity of their network pharmacies, I do want to highlight that there are good laws as well as bills that have been introduced that provide layers of protection for the pharmacies, and we'll continue to see some of the same audit trends that we've seen in the latter part of the 2023. Mailing delivery limitation, drug supply chain issues, NABP approved wholesalers, discontinued NDCs. But I want you guys to really know that PBMs update their provider manual on a regular basis. They update it on an annual basis. They also update sometimes on a monthly basis through educational updates. And we, as a firm, we really review and analyze those provider manuals and updates because that's the part of the provider agreement that the pharmacy signed with the PBMs. So PBMs audit trends like 5 years ago are different than what we see now, and they're going to continue to develop their audit practice in, and we as representatives of the pharmacies, we are tasked with recognizing the trend, analyzing the trend, and coming up with ways to deal with the audit trends.
And that's a good thing. That's a good point, Day, that you just raised, is that trends that we see from 5 years ago. The audits that we saw for 5 years ago aren't the same that we saw now. For example, in our previous webinar, we covered sort of the copay collection requirements or the copay documentation requirements. And before, it was just a register receipt, or it was just a proof of, the credit card transaction. And now we've seen it escalate to significantly more documentation. in current audits that we see from PBMs. So you're right, things change, documentation requirements change, manuals change, and so do terms and conditions. But importantly, so do your state laws. And also law generally. So that's something to keep in mind as well.
Definitely. We are running out of time, so I'm going to field some questions, but please feel free to contact us. Our contact information provided on this slide. For any follow-up questions that you may have, we'll be more than happy to answer your questions to the extent we can, or even hop on a follow-up call for you guys. So the first question, I think, Harini, you could answer this. Will these point of sale signature requirements be the same for specialty pharmacies if they are in retail network?
So it's an interesting question, right? Because they're asking if the requirements are the same for specialty pharmacies in the retail network. But I'd say you're a retail pharmacy if you're participating in the retail network right now. PBMs have specialty pharmacy networks, which are separate networks, which also have different terms and conditions. So to the extent that you're a specialty pharmacy or specialized in certain therapeutic categories, but participating in the retail network, I'd say that you're subject to the same delivery and proof of, signature and proof of delivery requirements that any other provider in the network is otherwise subject to.
Thank you. And Adam, I think this is for you. Could you please elaborate on drug invoice shortages?
Sure. And I think that kind of ties in nicely to another question that was in there. Drug invoice shortages are basically where a PBM says in a given 12-month period for drug X, the pharmacy only purchased 100 tablets while it billed 150 tablets. So there's a 50-tablet shortage for drug X, and PBMs seek to recoup whatever they reimburse the pharmacy for that 50-tablet shortage. One way that you can kind of help avoid those drug invoice shortages that was also brought up in a question, doing monthly or quarterly, semi-annual inventory checks to see what your existing inventory is. That way, when a PBM audit does come around, you have that extra bit of evidence to show what your existing inventory was ready to submit.
Okay. All right, Harini, the next question.
Yeah, I see it. Yep, I got it. It says, how do you prove cash payments? I believe this is related to copay collection, for example, such as Medicaid customers. So in relation to collecting copay in the form of cash, one, like I mentioned, you want to make sure that your POS system is set up properly such that you have a registered receipt to show that the patient's paying in paying in cash. Again, showing that they're actually paying to the pharmacy. Another thing that we'll see a lot of PBMs ask for is the deposit of cash into the pharmacy's bank account on a regular basis to kind of correlate with the collection of cash in the form of copays from patients. And so sometimes that also might include PBMs going a step further, saying we want to see that this particular claim's cash copay was then deposited a week later. And so we're seeing that kind of evolve, and we're seeing a lot more PBMs ask for that type of correlation between the collection of cash copay into actual deposits. And of course, that always raises the question of what do you do if there's you use it for petty cash and whatnot. So we're seeing PBMs ignore questions such as that of the practical realities of pharmacies and still place this onus on them to maintain this type of documentation. Another thing, and I'll emphasize this, and we cover this in our first webinar, is really to make sure that you have robust copay collection practices, policies in place, procedures in place, as well as a financial hardship policy in place as well. For example, what happens in the instance if a patient comes to you if they can't afford their copay? So those are important things to keep in mind and to make sure that your pharmacy is adhering to.
Alrighty, let me field the next questions. Can you elaborate which PBMs are doing member denial audits?
All of them.
It's basically all of them. All of them are doing member denial audits, and it could be part of the routine PBM audit, or it could be a fraud, waste, and abuse investigation. All these PBMs have a different discrepancy type or discrepancy code, but sometimes they mean the same thing. I've seen member denial discrepancies whether it be member denial, requesting the prescription, member denied, receiving the medication, member denied, paying the copay, member denied, consulting with the prescriber. All these are quite common discrepancy that's been utilized by all of the major PBMs.
Yeah, and unfortunately, it looks like we have a lot of questions, and I'm not sure that we'll get to all of them. But as they mentioned, you guys are certainly welcome to email any one of us so that we can address your question individually. But I think we can maybe answer another one or two more, maybe. Yeah.
Yeah, I see a lot of questions, coming in.
One of the questions I see is, are audits and disputes sometimes resolved in arbitration/court or outside of arbitration/court? If in arbitration/court, do pharmacies sometimes win their attorney's fees back per PBM contracts? And that's a good question, because obviously when we talk about sort of the timeline of an audit, you'd want to know how far it goes and what form you're also in. Your PBM contract and either in your provider manual or your provider agreement will discuss the forum and the method of which you can go ahead and raise a further dispute, whether that be through arbitration or whether that be through litigation in, for example, federal court. It depends on the specific provider agreement. We've seen different iterations, but most major PBMs have the same certain terms. Particular PBMs will have fee shifting provisions, and that relates to the question of, can you win back your attorney's fees? Certainly if you're the prevailing party, but on the flip side, if the PBM is the prevailing party, they can also ask you to pay for their attorney's fees. And so it's really important that before you proceed to engage in any sort of further action is that you understand what the terms are of that arbitration or litigation process, especially because you don't want to beat out not only your attorney's fees, but double your attorney's fees if you're paying for the PBMs as well.
Right, but I also want to highlight there are public judgments that we've obtained against major PBMs.
Yes.
These are monumental, I want to say monumental verdicts that we've obtained against the major PBMs are, in tens of millions of dollars. And I believe we've recovered over 100 million from PBMs over the past a couple of years, whether it be audit recruitments or DRFE disputes. So, I want to end our webinar on a positive note that pharmacies are in a better position than they were a couple of years ago against the PBMs. So if you have any questions, just feel free to contact us directly. We'll be more than happy to set up a follow-up call. Thank you.
Thanks, everyone.
Thanks.